Jason Geller is the regional managing partner of Fisher Phillips San Francisco office. He represents and counsels employers in all aspects of labor and employment law, including employment discrimination, wrongful termination, harassment, retaliation, and wage hour class action lawsuits, as well as employment handbook and personnel policy preparation and general preventive advice, including hiring, discipline, and termination practices. Jason has extensive experience defending employers in federal and state courts, as well as in investigations by the Equal Employment Opportunity Commission, EEOC, the DFEH, United States Department of Labor, and the National Labor Relations Board, NLRB.
Well, good morning or good afternoon, wherever you may be listening today. This is Jason Geller, Regional Managing Partner with Fisher Phillips San Francisco office, and we are here to discuss whistleblower claims avoiding the courthouse, something that as a litigator, I really, believe it or not, prefer to do when it comes to giving training and education to help employers understand their rights and responsibilities so that we can mitigate risk of litigation, protect employee rights, and have productive workplaces. I'm a managing partner of the San Francisco office of Fisher Phillips. For those of you who don't know us, we're a national employment and labor law firm exclusively representing management in all things having to do with the workplace, including, of course, addressing whistleblowing activities and other forms of retaliation alleged in the workplace. Today, we have a healthy agenda to cover in this very appropriate and timely topic, whistleblowing and what our agenda is. So I'm going to discuss today the rise in whistleblowing and retaliation lawsuits and my thoughts on why we are seeing such a burgeoning flow of these claims, both internally and on employer work sites, of course, that may or may not lead to litigation, as well as the actual lawsuits for alleged retaliation of whistleblowing. I will address the main critical laws that tend to protect employees and impose certain requirements on employers. When it comes to retaliation and whistleblowing, we're also going to talk briefly about government agency enforcement, although I won't be getting into great detail on audit defenses and the approach to audits today, but we will touch on that, and then conclude with some critical areas on the definition of the so-called protected activity, which is a critical conduct by employees that employers need to appreciate and be aware of because it is protected by the law and the employee needs to be treated appropriately. And then also finally discussing critical strategies on responding to whistleblower claims, particularly on in response to the internal complaint by an employee before any litigation ensues. So why do we see so much whistleblowing these days? And I list on the slide some of the reasons, in my view, that it occurs. And certainly the publicity is something that has promoted whistleblowing activity. There have been much publicity over the Securities and Exchange Commission's whistleblowing program. For example, there have been a lot of news reports and articles about whistleblowing, a lot of claims referenced in the press, some successful pieces of litigation that have been also promoted. And so this is certainly on the forefront of the minds of employers and employees alike. And then, of course, government activity with the government's attempt to ferret out whistleblowing. I mentioned the SEC program, among other government agencies, the Occupational Safety and Health Administration, OSHA, is another that administers a plethora of administrative whistleblowing programs, and there have been a lot of, so the government activity has certainly explained it. Legislation, I believe that if it's not every piece of new legislation, certainly in California, many pieces of new employment legislation always contain or often contain anti-retaliation provisions where they expressly state that an employer may be responsible for retaliation if an adverse action or a negative action by the employer occurs within, for example, a certain proximity of a protected act by the employee. So there's express prohibitions on anti-retaliation. It's in the legislation. Another key reason that, in my view, these claims are proliferating is that a lot of times courts will not dismiss them at summary judgment. Oftentimes, and I'll touch on this shortly, a plaintiff may rely on close timing, or not even necessarily close timing, but a matter of months between a protected act and, let's say, a termination of employment, and rely on a relatively short passage of time between those events to prove or to at least convince a judge that the case should get to a jury because the proximity in time suggests retaliation. Although the law does clearly say in many instances that timing alone is not sufficient, a lot of times courts will allow these cases to get to the jury because it's too close of a call, say many judges, to dismiss them at summary judgment, and the jury must decide. And then, as we all know, the outcomes are uncertain. And so I think these are the four main reasons why we see a lot of these claims. I could certainly offer some anecdotal information I hear from clients about shifting demographics, a younger workforce, and interest of younger workers in expressing themselves, being heard, and that has also contributed to a lot more whistleblowing activity, say some folks. Now, I mentioned at the very end of this slide that it can create liability where none exists. And what do I mean by that? Well, what I'm saying there is that the underlying claim that a person may be, or misconduct about which the person may be claiming, may in fact not have occurred. For example, somebody may make a complaint of sexual harassment at the employer. At the end of the day, it may be proven that there was no sexual harassment. Nevertheless, an employer could still be responsible legally for retaliating against that employee for making a good faith and honest complaint. So it certainly creates the basis for litigation when there really otherwise wouldn't need to be any whatsoever, because by virtue of the first or underlying complaint being or lacking merit or not being legitimate. Now, anecdotally, I put some interesting statistics here just before the Equal Employment Opportunity Commission and the DFEH, and these are a little bit stale, 2015 and 16, but I can tell you that in more recent years, the trend has been the same, which is upward. And as we can see, nearly 50% of all EEOC charges contain some claim of retaliation. And same similarly under the DFEH, if you look at nearly 50% increase in, or I should say 100% increase in retaliation claims or charges filed before the DFEH between 2012 and 2015, a staggering, precipitous, I should say, climb or ascension of these charges. And I will note that these statistics just deal with claims of retaliation for protected activity in the area of discrimination and harassment type of misconduct. They do not include statistics on other types of species of retaliation, such as claims brought under a whistleblower act or the False Claims Act or various provisions of labor codes or the common law, such as wrongful termination claims. And anecdotally, as a litigator where I exclusively represent employers, I defend them often in lawsuits as well as counsel them. to stay out of the courts. I can tell you, in most cases I see, there is some form of a retaliation claim alleged, and I've seen a lot more claims brought under the California Whistleblower Act, Labor Code 1102.5, in the last couple of years than I've ever seen before. So certainly my own personal experience underscores these very telling statistics. So what we need to talk about now, that we've established that retaliation claims are on the rise, and I don't see them diminishing at all, is looking at the elements of the claim. And one thing we all need to focus on is, very first and foremost, was there any protected activity? It's really critical that I at the outset that we understand there are a litany of statutes that prohibit some form of retaliation. They're all unique. I often find that litigants, lawyers, and clients and judges sometimes refer or consider retaliation as a monolith, that it means just one thing. If one thing you can learn from this presentation is this: every retaliation claim has its own discrete elements, and we must focus on what law is being invoked, what statute is a plaintiff suing under, what complaint internally might trigger the application of some statutes that are suggested or referenced by the internal complaint. We need to identify that and then look at what are the elements under that particular statute. And in most of these statutes and in the common law, there will always be the element number one, protected activity. So before a retaliation claim has any merit whatsoever, the employee plaintiff must establish that there was the requisite protected activity. Let's look at the first type of retaliation claim, species of retaliation claim that we often see: the wrongful discharge in violation of public policy claim, or if you're practicing in California, the so-called Tammany claim, based on a lawsuit against Atlantic Richfield a long, long time ago. And this claim is a common law claim that permits employees to recover tort-type damages, emotional distress, punitive damages, and other damages, tort remedies. And to establish the protected activity, the employee must show that he or she either reported an illegal act, refused to perform an illegal act, exercised a legal right, or a statutory privilege. Those are generally the four types of protected activities that would be required to support a claim in California for wrongful termination. Now, mind you, if you look in other jurisdictions, for those of us who are dealing with claims elsewhere, the elements can be very different. Some are more narrow than this. Certainly in California, not surprisingly, the list of potential protected acts is quite long. But I can tell you in other jurisdictions where I've dealt with claims, there can be wholly different elements. So again, bears repeating. Check to see what is the statute, what is the claim being alleged, what jurisdiction are you in, because protected acts may vary. Now, I mentioned that it must typically affect the public. And what that means is that the statute on which the plaintiff is relying must inure to the public benefit, meaning that it can't be something that regulates private conduct between the parties. An example might be, I'm complaining because the employer violated my own personal agreement to not pay me my relocation expenses, as an example. That type of complaint would likely not be sufficient under this wrongful termination claim, because it involves a purely private matter between the employee and the employer. Now, what about complaining about criminalize conduct, such as embezzlement or some crime. I can tell you that some authority might say that, well, you're reporting a violation of a crime. Usually a crime is something that the legislature has deemed to be of sufficient public importance that the conduct needs to be criminalized, that it would inure to the public benefit. And there are cases that will hold as such. There are also, though, cases where where courts have held that certain criminal conduct would not support a public policy claim. So the key is look to see what is the statute on which the plaintiff is predicating the wrongful termination claim. Just look at that statute and see whether it has the requisite public significance to support the claim. And under litigation, most of us know, or in litigation, that it's the plaintiff's obligation to identify the public policy, the statute or regulation that is supporting the claim. If the plaintiff does not do that, the claim will fail. And this can often be the battleground for summary judgment. Now, certainly in California, many plaintiffs rely on typical statutes like the Fair Employment and Housing Act or the Whistleblower Act, the Labor Code 1102.5, or some wage and hour law, which are undisputedly sufficient to support this type of claim. Where it gets more interesting is where a plaintiff might be relying on a financial regulation that might apply to a nonprofit corporation, where an allegation might involve alleged financial malfeasance or a failure to report something to the government under a particular rule or regulation. There, both sides, the plaintiff and the defendant employer, must evaluate whether the statute on which the plaintiff is relying or the regulation meets this critical standard that it affects the public. If it's purely a private matter, then there will be an issue. Let's segue into defining protected activity under different laws. Here, we're talking about the laws prohibiting discrimination in employment. So on the federal level, of course, Title VII of the Civil Rights Act, and then we've got similar state statutes, and I mentioned a few from other states. Most jurisdictions in the U.S. have some form of a local anti-discrimination statute. I mentioned some examples. Of course, in California, we contend with the California Fair Employment and Housing Act, or better known as FEHA, as we love acronyms in the legal business. And then, of course, Title VII of the Civil Rights Act. Under both the California statute and Title VII, for example, and again, this would be more than likely very common in other jurisdictions, there are two types of protected activity. So if we are dealing with a retaliation claim brought under FEHA or Title VII, the Protected Act needs to fall into one or two categories. It's either got to be opposition protected activity or it has to be participation protected activity. Let's take the latter first, which is more clear-cut. Participation protected activity means filing a government charge of alleged discrimination before the DFEH or the EEOC. It also includes being a witness or participating in some respect in an investigation by the EEOC or the DFEH. So it has to be some activity tethered to those two government agencies. I'll use an example of a Title VII case from another jurisdiction in which the plaintiff was participating in a mediation before the EEOC on the defense side of all things. And subsequently, she was terminated from employment. And without getting into the details of the case, the thrust of the allegation was that she was involved in participation type protected activity by virtue of being an advocate a lawyer participating in an EEOC mediation. The court there held that that was sufficient participation type activity. She was involved in an EEOC mediation, albeit as a mediator and a representative of the employer. That's enough to pass the test. So that's participation activity. Now, and certainly by virtue of being involved with a proceeding before the DFEH or the EEOC, the underlying matters involve alleged employment discrimination, employment harassment, or employment retaliation, all of which are prohibited by Title VII and FEHA, and certainly by other local, state anti-discrimination laws. That's critical because I want to make it clear that in order for there to be protected activity under these statutes, the underlying complaints or the underlying activity must be about or concern employment discrimination, harassment, or retaliation related to those items, because those are the activities expressly prohibited by Title VII and FEHA. So to use an opposite example, if one was making a complaint about wage and hour violations, they would not be relying on FEHA or Title VII because those statutes do not address or prohibit wage and hour violations. Instead, the employee would want to rely or need to rely on a statute expressly prohibiting wage and hour violations. To do otherwise would not be a sufficient protected act under Title VII or FEHA. And I can't tell you how often I have discussions with litigants about this very issue. There is no protected activity if the conduct is not prohibited by the statute in question. So now let's segue into the other type of protected act by Title VII and FEHA and similar state statutes. We call it the opposition type protected activity. And what this means is that the employee has opposed alleged employment discrimination, harassment, or related retaliation. So what is opposition? What does it mean to oppose? And generally speaking, the trend in case law across the country has really broadened the scope of the definition of opposition type activity. It doesn't just include, by all means, somebody stating, I oppose discrimination, or complaining about sexual harassment, to use some examples. It goes well beyond that. Silence. For example, if an individual is accompanying a coworker to human resources because that coworker is going to complain or lodge a complaint about discrimination or harassment, is the fact that a silent coworker who merely walks the person over to human resources engaged in opposition protected activity? Well, the answer is yes, says at least one federal district court. And so silence, the act of accompanying somebody to lodge a complaint, can be a method of vocalizing opposition. And I say vocal in quotes. Similarly, what about answering questions in an investigation where the person who is now bringing a retaliation claim wasn't the one who actually initiated an internal complaint, but instead was just a witness in that internal investigation by the employer, and that person was answering questions? Is that opposition protected activity? Yes, it can be. There are various cases that stand for that proposition. This person wasn't even the one lodging the complaint to begin with. Opposition activity. But what about posing questions? Most of us may be familiar with the Yanowitz versus L'Oreal case that came down in, I believe, 2005 or 2006. If you haven't read that, that is a seminal case in California Supreme Court case on the elements of retaliation under FEHA. There, the employee asked a question to her supervisor: why do I need to terminate this other female employee. That was all that the person did, just ask the question. The court said that question in and of itself could be opposition activity under the Fair Employment and Housing Act. And by way briefly of background there, in that case, the allegation was that the supervisor had directed the plaintiff to terminate this other employee because the other employee was, quote, not hot enough, close quote. And that's what provoked a question by the plaintiff, why do I need to fire this person? And that was deemed sufficient to be opposition type activity. And from the defense perspective, one might argue, well, the employer has to be a mind reader then. How would we know that this person was in fact protesting sexual harassment or discrimination by asking that question? Others might say from the plaintiff's perspective, well, it's obvious that that's what she was doing when faced with the directive of the supervisor who had previously said the person is not, quote, hot enough. So it is very challenging, but as you can see from some of these examples, this reflects a very significant trend over the years by our state courts and federal courts to expand the definition or the construction or interpretation of what it means to oppose discrimination or harassment in employment. Now let's look at a couple other statutes in defining what is protected activity. Under the Federal False Claims Act, the protected act there is submitting a false or fraudulent claim for money to the government, or it can also be reporting or initiating action against the employer, reporting it to the government because of such false claims. And the classic situations here involve somebody who might complain that an employer is submitting false or fraudulent claims for reimbursement for overtime expenses to the government when the overtime expenses of its employees were never incurred, or submitting a false claim for reimbursement to Medicare, for example. Those are types of protected activities under the Federal False Claims Act. Or we look at the National Labor Relations Act, under which there's been some recent activity by the National Labor Relations Board. But notwithstanding that, the statute protects individuals from protected concerted activity regarding an employee's working conditions under Section 7 and Section 8 of the National Labor Relations Act. So what does that mean? Well, that means concerted means working with employees working in concert with more than one. So in a group, it can be two or it could be more, and either expressing a desire to change something about their working conditions or protesting something having to do with their working conditions. Now, in California, we have our own labor code statute, labor code section, I believe it's 230 and 232, or 232 expressly, 232.5. I apologize. I don't have the statute off the top of my head, but they are similar statutes that protect employees from disclosing information about their working conditions and their compensation. They're two separate California labor code sections, which have been on the books for a long time. So employees who are engaged in that kind of activity, requesting changes in their working conditions, or in California or even under the NLRA, disclosing information about their compensation can be enough to satisfy the protected activity standards under the NLRA or under California law. I'll give you an example where I defended an employer against an NLRA charge in which the employer allegedly fired somebody for raising questions about the quality of the health insurance package that the employer was promoting. They were taking issue with the scope of benefits, and the employee claimed there that the discussion about benefits and the quality of benefits was a discussion about working conditions, that the employer's termination of her allegedly because of that was a protected activity. This is certainly an area where we've been well aware over the last several years, particularly under the National Labor Relations Board under the Obama administration, where there's been a real assailant attack on and review of employers' handbooks, confidentiality policies, confidentiality agreements, social media policies, where they might arguably, so the argument goes, discourage or chill employees from engaging in protected concerted activity under the National Labor Relations Act. And I'm sure many of us know these rules apply not only to unionized workforces, but to non-unionized employers. And the NLRB has made itself very relevant to the roughly 95% or 94% of non-unionized workforces or workplaces in the country that these rules apply to them. So very important to be mindful of what the employer policies say and what conduct they discourage, and whether employers are taking adverse action against employees for disclosing information about working conditions. And not surprisingly, working conditions has been construed very broadly. Now, I want to segue into some Whistleblower Act protected activity claims. And I mentioned several state whistleblower acts throughout the country. And in general, most of these statutes protect somebody from reporting illegal activity or from resisting or refusing to be involved in illegal activity. At the very least, they usually protect that type of conduct by an employee. Certainly reporting incidents of illegal activity to a governmental agency is likewise protected. These are common themes across the country in these state law whistleblower statutes. Now let's move to common elements of these claims. Many of them, as I said, deal with reporting or disclosing illegal acts to the employer. Now, depending on the state statute that applies, the type of protected activity, as I alluded to earlier, may be very unique and different. In California, under our Labor Code Section 1102.5, the three main types of protected activity would be an employee's report of illegal activity to a governmental agency, or an employee's internal report or disclosure of illegal activity to the employer itself, not to some outside agency, or number three, an employee's refusal to do something that the employee claims is illegal. So regardless of what type of protected activity the statute might enumerate, most of these statutes, and certainly this is true under California law, under the Whistleblower Act, there must be a good faith belief, reasonable and good faith belief on the part of the employee that illegal conduct was going on. And the statute, unfortunately, in California does not limit illegal activity to any particular type of misconduct. If it is made illegal, then theoretically it would be sufficient to support a claim under the California whistleblower statute. Certainly, I think there are public policy arguments that employers may raise to say that, well, an internal complaint by an employee that he or she didn't receive something to which she was entitled under some private contract, maybe that's illegal because it constitutes a breach of contract, but on the other hand, is the Whistleblower Act intended to um, uh, uh, encourage the reporting of significant illegal acts such that it's not going to sanction or protect any complaint of alleged illegal activity? I think those questions may be ripe for further resolution by the courts. But as it reads now, illegal, I can say this, is quite broad. And typical types of illegal acts, alleged illegal acts that get raised are um, not only discrimination and harassment and retaliation. As I said, those are predicated under the other statutes, but more commonly, in my practice, I've seen a lot of claims rest on um, alleged financial malfeasance or a failure to comply with some particular regulation that applies to the employer, um, uh, things of that nature. But there must be a reasonable and good faith belief that the illegal activity had occurred. Now, the employee ultimately does not need to be correct. The employee could have a reasonable and good faith belief that something was wrong, and then after trial, it's determined that there was no illegal act. But if the employee had some factual basis for it, that could be enough to support the claim. They don't have to be right. Now, this is an area that both sides in litigation certainly need to explore to determine whether there is a factual basis for the claim. The employee still needs to have a reasonable factual basis to conclude that there was some illegal conduct going on. And typical inquiries in this area will be, well, what information did the employee know? What expertise does the employee have to make such conclusions of illegal activity? What type of investigation did the employee do to consider that the information was illegal? Obviously, they're not lawyers and they're not held to be a higher standard. That, by the way, in and of itself makes in-house counsel whistleblowing claims very challenging because lawyers were held to a higher standard. We're expected to research the law and have a sense of whether something is actually illegal. Employees, the bar is lower, as one might reasonably expect. Nevertheless, there needs to be facts supporting the belief. So that's going to be an area that both sides are going to want to explore, certainly in litigation. And if an employer is responding to an internal complaint, they should really get a sense of why the employee drew the conclusion that there was illegal activity. Now, what about an employee's job duty? Let's say my job is an investigator, and I'm a human resources investigator. I'm paid to investigate and report incidents of misconduct. Does that mean then that every time I do my job, I'm somehow a whistleblower and I can bring a lawsuit every time? In certain jurisdictions, this concept, the answer would be no under this concept called the manager's rule. More about that in a moment. Under the California statute that was, amended a few years ago, it expressly states that one can be engaged in protected activity even if the person's job requires them to report illegal activity. So the notion of the manager's rule is that you should not be permitted to sue for protected activity if you, in reporting illegal conduct, were doing what you were hired to do. Not all jurisdictions recognize the manager's rule, and it will depend. It's often a creature of federal law, and it'll depend on what jurisdiction you're in. I believe in the Ninth Circuit, the question is not totally settled, but in other jurisdictions, it varies. Circuit courts of appeal have said that it does apply. Others have revised it to say it applies in limited circumstances. And it often, as you might imagine, doesn't preclude somebody whose job it is to report illegal activity to become a whistleblower. There has to be evidence, though, that at some point that employee stopped doing his or her job of reporting illegal activity and instead is now wearing the hat of a whistleblower. And that might occur, for example, when an employee has reported the conduct and nothing has happened, nothing has been done about it in his or her view, and the employee then takes it to a new level, reports it to a higher level of management, or goes outside and reports it to a governmental agency, for example. That might be evidence of a shift from one doing her manager duty to now becoming a whistleblower. And in California, the statute expressly says that one cannot violate certain privileges, like the attorney-client privilege, for example, or trade secret privileges or trade secret rights to engage in the protected activity. So in other words, under California law, perhaps it is that the employee cannot take a trade secret and use that, disclose that as part of his or her protected activity. There would be a limit. Now, I say perhaps because that's what the statute says. I'm not aware of any authority that has expressly dealt with that in California, but I can tell you that under the federal law, the Defend Trade Secrets Act, that statute expressly allows an employee to share protected information like trade secrets with his or her attorney or with the government and still be entitled to protected activity or under the applicable statute, the Defend Trade Secrets Act. And whether that outcome would be the same under California law may very likely be possible. And of course, employees are entitled to the panoply of damages under the Whistleblower Act, punitive damages, compensatory damages, and likely potentially attorney's fees. Now, let's talk about another critical element of a retaliation or species of retaliation claims in general, I should say. All whistleblowing retaliation claims have three main elements. And as I said, depending on the statute, they will differ. There's protected activity. We've been talking about that. Now let's talk about the second element, adverse action. The employer needs to have done some type of negative action, or adverse action is the term of art, against the employee because of the protected activity. So when I say because of, that's the third element of of all whistleblowing and retaliation claims. There must be causal nexus. You've got protected activity, you've got an adverse action, and they need to be connected. Causal nexus or retaliatory animus. So now we're talking about what is an adverse action. As I said at the very beginning, take a look at the statute or the common law on which the employee is relying to decide whether there is a viable claim. Wrongful termination claims, for example. Termination. There must be a termination or, under California law, a demotion. If there was something short of a demotion or a termination, generally speaking, that is not going to be there's not going to be an adverse action to support a common law tammany claim or wrongful termination claim. Take a look at different statutes. The Whistleblower Act in California will define adverse action different than FEHA or Title VII might define an adverse action. So here are, the obvious ones, and usually, if I say, for example, under the standard under California law, is that there has to be a materially adverse change in the terms and conditions of employment in order for there to be an adverse action. And under the Burlington Northern Standard under Title VII, the Title VII case that came down within the last 10 years, that case has a similar standard for what is an adverse action. So it can't be something trivial. And that's why it's really important, if we're dealing with an internal complaint or we're dealing with litigation, we need to understand, was there an adverse action? Was it trivial? Was it a material, or was it, on the other hand, a materially adverse change in terms and conditions? And these are the common examples on slide number 10. Discipline, demotion, termination, retaliatory refusal to hire are examples of cut and pay, probably as well. Depends on how much, but generally, yes, it would be sufficient. The notion is that the adverse action is reasonably likely to discourage protected activity. That's why it has to be something beyond a trivial slight. Now, if we go to slide 11, these are relatively lighter types of action. Threats generally, a threat to do something adverse is generally not going to be sufficient. There needs to be actual tangible action taken. I mentioned the Burlington Northern case about changes of terms and conditions outside of the physical workplace. And many of us may remember under Title VII, in that case, the employee was deprived of pay during an unpaid suspension over the holidays. And she said that she didn't have enough money to buy holiday gifts for her children. And the court considered that and said, well, that could be an adverse action because it significantly affected her and could have discouraged protected activity. So that was conduct that really had nothing to do with work. It affected her personal life, and the court said it could be sufficient to support the claim. But other things that we need to focus on that are short of a termination or a demotion. I mean, what about a transfer? The transfer cases are legion. It depends on the facts. This area is highly factually intensive. So when you're in discovery or you're addressing an internal complaint or you're making an internal complaint if you're an employee and the issue is whether there was an adverse action, we need to really look at these facts. A transfer where there's no cut and pay or a shift and change in command or promotability or no change in job duties, just a transfer to another position within the organization. There isn't a long commute that was necessitated by it. Absent those factors, a transfer more than likely will not be an adverse action. Of course, Jason's caveat is it depends on the circumstances, a typical lawyer's answer, but it really does. Transfers are highly factually intensive, and employers need to think carefully before transferring somebody if they had engaged in recent protected activity, because it can raise a question about whether there was alleged retaliation. Other things, bad reviews and disciplinary measures, it depends on how severe it is. There are cases that say a write-up or a warning in and of itself may not be a sufficient adverse action. It's not a material change to the terms and conditions of employment. If it's a performance improvement plan or a PIP in my business where termination is threatened or reasonably likely, that's a different story. I've litigated issues over office location moves, changes in chain of command, and I've had courts say that those are insufficient under the facts that I presented. And the last thing I want to briefly comment on is this retaliatory hostile work environment claim, and that's where an employee had engaged in protected activity, and as an example, her coworkers or his coworkers become aware of the protected activity and then engage in a pattern of pervasive, we get the words, right? Familiar words for hostile work environment claims. There's a pattern or there's pervasive slights and ostracizing and other types of conduct that in and of themselves would never rise to an adverse action, but when they're treated collectively, it may become a sufficiently severe, or I should say a sufficiently pervasive hostile environment using much of the same analysis as you would in an environmental claim to establish that all those petty slights taken in aggregate are tantamount to a retaliatory hostile work environment. I've seen these claims that often get overlooked internally by human resources teams, something to be aware of. That can be an adverse action. Now, um, before I segue into government activity, I do want to mention one thing about causal nexus, and I mentioned this earlier. There needs to be a connection between the protected act and the adverse action. A couple bright line rules about this. Number one, generally speaking, timing alone will be insufficient to create a tribal issue of fact for the litigators who are listening to prove retaliation or whistleblowing. There needs often to be more than that. Now, what is close timing? What's the exception? Under the Breeden case, which is a U.S. Supreme Court case that came down several years ago in the Title VII context, I think there it was 20 days in between the adverse act, or it might have been 2 days, I forget, but it was certainly with less than a month between the adverse action or the protected activity and the adverse action in a court. The court there said that's going to create a tribal issue of fact, at least on whether there is. But if it's a matter of months, 2, 3, 4 months, the cases vary. And certainly from both sides, plaintiff or defendant, you're going to want to argue if you're a plaintiff that 3 or 4 months is close timing. It's enough to create a tribal issue of fact. The employer is going to say, if that's all the plaintiff has, it is insufficient. There usually needs to be something besides timing unless you've got super close temporal proximity. And so that could include a negative comment by a manager, for example, respecting the complaint, or a failure to investigate, or some disparate treatment where the complaining employee claims that others who had not complained about or engaged in protected activity were not similarly subjected to the same adverse action. That type of evidence may be sufficient to create a tribal issue on causal nexus. The other issue on causal nexus is that if there were intervening, I lifted this from a very skilled defense attorney I heard speak years ago, intervening nice things. If the employer had done nice things for the plaintiff between the time the plaintiff complained and, let's say, the termination, well, those intervening nice things may cut off the chain of causal nexus or causation. Similarly, if the employee had been engaging in prior misconduct before the protected activity, and that misconduct persisted thereafter, which culminates in a termination, the employer would argue that the same misconduct that preceded and succeeded the protected activity was the basis for the adverse action. That also can be used to undermine or eliminate an inference, or prove or eliminate the element of causal nexus in a retaliation or whistleblowing type of situation. And likewise, similarly, ineffective and prompt investigation can also be used to undermine an inference of causal nexus. So the question of causal nexus, it's highly fact intensive, and these types of things, as I've just illustrated, are very critical to be explored by both the employee and the employer. Let's segue now into government agency involvement, and certainly this has been a focus of many agencies. I can tell you the Securities and Exchange Commission has had a robust whistleblowing program, as I had mentioned earlier. Many governmental agencies like the Occupational Safety and Health Administration, they actually enforce whistleblowing provisions of an array of statutes. And I haven't counted them in a while, but I want to say it's no fewer than 10 different statutes where OSHA is administering and enforcing whistleblowing provisions under the statutes. And governmental agencies are investigating it. If you look at, similarly, the state level, the Division of Labor Standards Enforcement, the DLSC in California, has a Retaliation Investigation Unit, or RIU, And in the past, they have been fairly active, not so much in my experience in the last year or two, but that was recently in the last few years revamped and by the DLSC's publications enhanced to make retaliation claims more efficiently investigated, and certain industries have been targeted in this area. So we all need to be aware that governmental agencies are investigating retaliation claims. Now, as I said here, referencing the SEC whistleblower statute, this is a little bit stale, 2015, $37 million in claims, and they pay out a lot of money in to tipsters, and $100 million at least as of that point. And I know that that amount has increased, and the SEC has done a lot of work to publicize its programs. And as I mentioned at the outset, this publicity alerts people to the need or the ability to speak out and protest, whether it has to do with securities violations, which would be obviously the type of protest that the SEC would be concerned about, securities law violations. But even broader than that, it wakes people up to the need to report alleged misconduct and to understand their rights and protections when they do so. Slide 14, I mentioned earlier about the NLRB and the SEC as an example. They have been focusing a lot on confidentiality agreements, and I think they've also reviewed settlement agreements in litigation, but certainly confidentiality agreements I'm aware of, where they are looking for language there that discourages people from reporting alleged violations of the securities laws to the SEC, and they will impose penalties about it. And this is something they've devoted quite a bit of resources to in that area. The Defend Trade Secret Act, as I said earlier, this is a statute that is intended to protect trade secrets, but it curiously has a provision that protects whistleblowers when they use protected trade secrets for purposes of engaging in whistleblowing activity. And if you haven't done this already, be sure, to the extent you have trade secret agreements and confidentiality agreements, that you have the requisite disclosure under the Defend Trade Secrets Act about employees' rights to do these things. If you do not include that, then the company, the employer, can lose certain rights to enforce their trade secrets, including recovering attorney's fees. So really important that the requisite disclosure under the Defend Trade Secrets Act be included in all confidentiality agreements that address the protection of trade secrets. So here, how do we spot protected activity? When I'm working with employers, I often ask them if they say that they are intending on terminating somebody. For example, I ask, did the person report any misconduct? Because the scope of what is protected is ever growing, certainly under California law, with all the legislation we have, there are more and more activities that are expressly protected by the law. Employers need to be aware of it. Employees need to be aware of it so they understand their rights. The obvious other types of protected activities are different kinds of leaves of absence. We have a plethora of leave laws in California, for example, most of which are protected and could support either an individual private right of action under the statute, the labor code, or even possibly a public policy claim. Certainly other obvious protected activities are requests for accommodation, disability accommodations, and issues related to industrial injuries, where workers' compensation claims have been filed. All protected activities. And so at the end of the day, what I'm saying is, if you're on the employer's side, be mindful of the conduct of your employees before taking adverse action to make sure that you're not unwittingly taking adverse action against somebody that's in violation of the law. Similarly, as I mentioned about social media policies, what do the policies prohibit? Are they going to chill protected activity? if you discover criticisms of the employer on a website or social media, are you going to take adverse action? Is that protected under the National Labor Relations Act? Very important types of analyses that need to be had. So at the end of the day, the best thing that employers can do for both themselves and for their employees is understand how to respond to complaints, have effective published complaint procedures so that employees know that they can report misconduct and that it in fact will be addressed and reviewed. Not only is it good for the workplace, it's a large risk mitigator when it comes to retaliation claims because it shows that the employer is not interested in burying claims. In fact, they want to unearth the claims so that they can be addressed. Other issues to look at would be the contents of job descriptions to see whether there in fact is a job role for managers where, for example, they are encouraged to report misconduct. They are encouraged to alert human resources if an employee makes a complaint. They are encouraged to spot misconduct on their own and take action. Those types of factors go into the analysis of whether there's causal nexus between a protected act and an adverse action. It's also very important that the employer have good policies on investigation protocol. It's got to be flexible because every investigation will differ depending on the facts and circumstances, and that the employer take important steps to evaluate who's going to be the investigator, because that's probably one of the most important things when dealing with an internal complaint. Who will be the investigator? Is that person appropriate? Is that person objective? Is that person well trained to address the issues? All of which are important to vindicating, protecting employees, and to mitigating risk in litigation. And generally speaking, if we look at California law in the anti-harassment area, the claim of failure to prevent harassment, as many of us know, obligates a prompt and good faith investigation that be taken immediately after a complaint is made. And obviously, every situation is unique and investigations can take longer, some shorter. It really depends on a lot of practical circumstances and the breadth of the allegations. But it's good for both sides that an investigation be had immediately and handled appropriately, and if necessary, through advice of counsel. Finally, the best response is making effective fixes and remedying the situation if, in fact, there was a problem. And certainly, from both sides, the employee does not want to be punished for making a complaint in good faith and honestly, and then the employer also wants to be mindful of any risks for subsequent discipline, because that could give rise to an inference of retaliation, which the employer needs to avoid. Now, and in terms of mitigating that risk, red flags that can suggest retaliation, maybe stricter supervision. Suddenly, the employer is requiring higher performance standards or expectations. The supervisor may be talking to other people about the complaint. These are things that the employer needs to be sensitive to so that it can take action to squelch it before it devolves into a potentially hostile situation that could lead to a retaliation claim, which neither the employer and the employee would like. The last couple points and that I want to mention on governmental complaints: when the government knocks and an audit needs to be conducted, it's very important from the employer's perspective that they train the gatekeepers, the people who are initially involved in responding to the complaint, so that the employer has a measured response and that employees are treated respectfully and in ways that will mitigate risks of retaliation claims to the extent that they are involved in the investigation by the government. Very critical that management be aware that if the government requests people to be involved in an investigation, that they be permitted to. And as I alluded to earlier, we don't have time to discuss the details of addressing an audit. This is very high level, but very important that you plan for it and anticipate it. As one person used to tell me, an ounce of prevention, and you know how the rest of that goes. And with that, I am concluding my presentation. Thank you very much for attending this webinar. And if anybody has any questions about these issues, feel free to call me at 415-490-9020 or email me at jgeller@fisherphillips.com. Thank you very much.